Welcome, Justice Watchers. Join me tonight as we watch the Chad Duerman sentencing hearing. Now, Chad Duerman is one of the most heinous criminals that exist. This man is accused of gunning down his 3 young sons. This was one of the cases that I covered at the very beginning of this channel's origination. So it's kind of bittersweet to see it come to an end without a trial, because I fully expected that we would cover any trial that came about. Now, one of the notable things to know about this case is this was a famous case where Court TV was advocating that this case was a case that the presumption of innocence should be suspended on, because Julie Grant was advocating that certain crimes, there should be a carve out for certain crimes in our society, and that to which an individual should just be sent right to prison. And of course, I was outraged by that. I'm completely outraged by what this man is accused of doing. But at the same point, I feel like, as I've always said, we are defined by how we treat the worst of our society, and our justice system gives rights to those accused of the most heinous acts, to those accused of minor traffic violations. You get the same set of rights. You have the right to due process. You have the right to confront your accuser. You have the right to trial. And in fact, his attorneys very, very vigorously defended him, to the point that they actually got his statement thrown out because the police did not follow or respect his rights. Again, looking at this case as if the acts that this man was accused of doing somehow allowed them to trample on his rights. Anyways, Mr. Duerman was expected to go on trial at some point later this year or early next year, and this sentencing hearing came up out of nowhere. We're going to watch it, and he essentially, what we're being told right now is that he changed his plea and he's going to be sentenced. So it's kind of an impromptu hearing. So enjoy it. We're going to watch it, and then we're going to react to the hearing after we get done watching it. So stand by after the hearing for my thoughts on the sentence, on the case, as we discuss it. So let's head into the courtroom.
All right. Court meeting, please. Good afternoon. We are here on State of Ohio versus Chad Duerman, case number 2023 CR 407. Mr. Duerman is present with counsel, Mr. Myers, and Mr. Haynes. The state's present, represented by and through Mr. Colby, the county prosecutor, Laura Barron Allen, first assistants Catherine Terpstra, and Mr. Clay Tharp. And we're here this afternoon because I have been advised that a plea agreement has been reached in this matter. And there's a couple of things that we need to address before going into that lengthy process. First of all, there's obviously media here. They're live streaming this. There will be 2 of the victims are going to appear this afternoon, and at least initially, statements are going to be read on their behalf, and they may address the court as well. They have requested, and pursuant to Ohio Superintendent's Rule 12, they are not to be imaged in any fashion by the media. There are not to be any still photographs taken of them, period. There's not to be any videotaping when they appear. There's to be no image of them, period. Cannot be live streamed. It's my understanding that Ms. Barron Allen may read the statements, and they can hear the statements, but do not, under any circumstances, photograph them or videotape them when they come into the courtroom, when they are standing at the podium, and when they leave the courtroom. So I hope all of you understand that. I'm sure you do. You're professionals, so make sure you follow that admonition. Mr. Myers, anyone from Mr. Norman's family going to speak that would not want to be imaged as well?
No.
Okay.
Thank you for
All right. All right. And then there's a couple of other things that we're going to put on the record initially just to clarify some waivers. As will become more apparent throughout this process and the plea that is going to be entered, there are two things that could be applicable but really will not be applicable. Two of the charges that Mr. Norman will be entering pleas to this afternoon are felonious assault. They are second-degree felony offenses. In Ohio, under the Reagan-Tokes Act, there are certain notices that I have to provide to anyone who is sentenced under the Reagan-Tokes Act. There are notices as to when they may be released. And as I've indicated, as we go through this process, those notices are absolutely inapplicable here. And for me to go through that process, number one, would be simply a vain act because they will not be applicable. So as to the Reagan-Tokes piece of this, is that your understanding, Mr. Colby, that that can be waived?
It's my understanding, Judge, yes, sir.
And Mr. Myers, on behalf of Mr. Dorman, it's your understanding that he's willing to waive those notices.
That is correct.
And just for the record, I mean, there will be times when I ask both you and Mr. Haynes to comment, but primarily I'll address questions to Mr. Colby and to you. And that's no slight to anyone else. That's just easier. All right.
Interrupt. Something just occurred to me that the defense would like to acknowledge and agree that before we went on record for this hearing at, I believe, 1:15 this afternoon, the state caused to be filed at Andrews time by this court.
I'm getting to that.
Okay.
Okay.
Acknowledge jurisdiction.
No, that's down my checklist.
All right.
The second item is Mr. Norman is going to be entering a plea of guilty to 3 counts of aggravated murder. And there were aggravated circumstances returned on all of those, which obviously made him eligible for the death penalty. The state, as part of the plea agreement, which will be discussed shortly, has dismissed those 9, all the aggravated circumstances in each of the 9 aggravated murder counts. So those aggravated circumstances have been dismissed. That entry has been filed with the clerk, and there's a record. So consequently, this is no longer considered a capital case. And Mr. Colby, that's your understanding, correct?
Correct, Judge.
Okay, and Mr. Myers, that's your understanding as well?
Yes.
And the reason we put that on the record is because in all other proceedings, when this was a capital case, there was a court reporter physically present taking notes, which is required, or transcribing the events, which is required. And because this is no longer a capital case, the court reporter is not present. Obviously, it's being recorded. All these microphones pick up the sound, but that's the reason why we have made that part of the record. And then the other piece of this is, given the nature of the offenses that Mr. Dorman will be entering a plea to, normally he would be required to register as a violent offender. Again, as we'll work through this, the violent offender registration is inapplicable. And rather than read something that is essentially a vain act, similar to Reagan-Tokes, to read that's a vain act because it doesn't apply, both the state and the defense are waiving any necessity for me reviewing the violent offender registration requirements. And Mr. Colby, correct?
That is correct, Judge.
And Mr. Myers, correct?
Correct.
All right, thank you. So we're going to start this plea process. It's a lengthy process. It's important to know that I don't want any people leaving in and out of the courtroom. You're here, you're here. If you leave, I prefer you don't come back because it's disruptive. And I prefer not to have disruptions for obvious reasons. It's a very serious process, and we need to get through this effectively and efficiently. This is not a race, but it's much better if there's just no in and out of the courtroom, except for the fact that the victims will be brought in at some point in time. They're not here now. And so I'll go ahead and then get started with this. And again, I've acknowledged counsel and the parties, and we have, and I also know that the victims have been notified of this hearing, and they are present. I've already discussed the requirements of the media regarding photographing the victims when they are here. And the two victims that will be here, at least at this point, will be Laura Dorman and Alexis Skeen, Mr. Dorman's former wife and stepdaughter. And those are the only two that will be here. And obviously that prohibition of recording in any fashion will apply to them. And initially, Mr. DeCalvi, if you would represent, if you would state on the record the nature of the plea agreement that has been entered into in this matter.
Yes, thank you, Judge. It is an agreement, Your Honor, between the state and defense and the defendant will enter a guilty plea to count 1, aggravated murder. That involves killing of Clayton. The defendant will enter a guilty plea to count 2, aggravated murder. That involves killing of Hunter. Guilty plea to count 3, aggravated murder, involving the killing of Chase. Will also enter guilty pleas to counts 18, felonious assault. That involves the actions he took against Alexis C. And he will enter a guilty plea to count 20, felonious assault, for the actions he took against Laura. The additional recommendation, Your Honor, is that count 1 will be life without parole, consecutive to count 2, which will be life without parole, consecutive to count 3, which will be life without parole, consecutive to count 18, which will be 8 to 12, consecutive to count 20, which is 8 to 12 years in prison.
Well, and just to correct, the Reagan-Tokes piece of this is complex, and that the actual sentence for count 18 and count 19 would be an 8-year minimum sentence on each, served consecutive, or 8 rather, an 8-year minimum sentence served consecutively with one another for a 16-year minimum prison term. And then under Reagan-Tokes, I'm required to take 50% of the most serious felony offense, which would be 18 or 20, doesn't matter, which is 4, add that to the minimum. So the actual sentence that if it was just Reagan-Tokes only would have been 16 to 20 years, and obviously served consecutively with counts 1, 2, and 3. Correct? And Mr. Myers, that's your understanding as well?
Yes, that's our understanding in our total agreement, that I think the court has just now adequately, state's counsel, summarized Reagan-Tokes as it really doesn't apply here.
Yeah, and I'll go through that through the plea because I have to, but nevertheless, we're all on board with that. And I know, Mr. Colby, you have discussed this fully with the victims in this case, and they're on board with this. They're in agreement with the plea agreement, with the agreed prison sentence, and they're also willing to go forward today with sentencing without the necessity of presenting a victim impact statement, which would normally be presented through a pre-sentence report, and we'll address that momentarily as well. But that's correct. And this is obviously the best plea bargain that has been or will be presented to Mr. Dorman. All right. And that's your understanding as well, Mr. Myers.
It is.
All right. And as I've indicated, it is also the dismissal of the aggravating circumstances has been filed. So those are, as they say, off the table and Mr. Dorman is not eligible for the death penalty. We discussed the aspect of the no longer the necessity of having a court reporter physically present in this process. And I know, Mr. Myers, we also discussed that as a result of the plea agreement, you will be, on behalf of Mr. Norman, withdrawing his written plea of not guilty by reason of insanity, and you'll also be withdrawing the motion that was filed to be heard Monday regarding the serious mental illness factor under 29025. Is that correct?
That is correct on both issues, Judge.
Okay, and I'm sure you've fully discussed that with Mr. Dorman, and he fully understands why that is being done.
I believe he does.
All right, thank you.
We have in fact discussed it.
I'm sorry?
And we have in fact discussed it with.
Okay, I know. And I'm sure that you and Mr. Haynes have fully discussed the agreed prison sentence as well as the agreed prison sentence with Mr. Dorman, and he is in full agreement with proceeding today as outlined by the state, and of course your concurrence in the plea agreement and the agreed sentence.
That is correct. With funds to be imposed today.
All right, and we'll go through that as well. And Mr. Dorman, prior to this agreement being made, did Mr. Myers and Mr. Haynes fully review with you all the evidence that had been presented to you or to them, discussed with you all the possible defenses you may have to these charges, reviewed with you, explained the trial process for a death penalty case and the sentencing aspects of that, and did they answer all your questions regarding those matters sufficiently for you?
Yes, Your Honor.
Okay. And your voice is strong enough. Just keep it up. That's going to, we're obviously making recordings, so just make sure you keep your voice up. And before I ask you any questions going forward, I need to make sure that you have not taken anything, even prescription medication, that would interfere with your ability to understand and comprehend what you are doing this afternoon. Is that correct?
Yes, Your Honor.
And you're clear-minded this afternoon?
Yes, Your Honor.
And Mr. Myers, I know the two of you have met with him and discussed this matter with him. Obviously, you've had a number of contacts with him, obviously, but are you satisfied that with your discussions with him today and this afternoon that there's every indication that he's fully aware of what he's doing, not impaired in any way as far as being able to understand what he's doing and comprehend the process that we're about to engage?
Yes, Your Honor, that is my understanding, and I'm sure Mr. Haynes joins in that judgment as well.
All right, Mr. Haynes is, Mr. Haynes is nodding yes. And Mr. Dorman, up to this point in time, have you been able to understand everything that has been discussed, both what I have stated, what the prosecutor stated, what your counsel has stated up to this point in time?
Yes, Your Honor.
And if at any time during this process, Mr. Dorman, you want to talk with your attorneys about anything, just let me know, and we'll make sure that you're able to do that privately and confidentially. And if you feel you need to take a break at any time during this process, again, let me know, and we can accommodate that as well. And candidly, if something comes up, counsel need a break, we can take that break as well. Like I said, this is not a race. We just need to pursue this appropriately. And Mr. Dorman, if at any time during the process I say something to you that you do not understand, or I ask you a question that you do not understand, please do not hesitate to ask me to state it again, rephrase it. And if you still don't understand, you can talk to your counsel about it. You understand that. I know you graduated from Amelia High School. You attended Claremont College for a short period of time. And I'm sure that you fully understand and comprehend the English language. Is that correct? Fair to say? All right. And it's very important, Mr. Dorman, for you to fully understand that the decisions you're making and the consequences of those decisions. And I must rely on your responses to my questions to determine that you do understand what you're doing here today, that you're entering your pleas knowingly, intelligently, and voluntarily, and that if at any time there is a question, you need to let me know so I can clarify that. You understand that?
Yes, Your Honor.
And you should not interpret anything that I say here today as any type of an indication that I think you should or should not plead guilty. I'm not trying to talk you into or out of anything today. The decision of whether to plead guilty or not to plead guilty is yours alone. You understand that?
Yes.
I'm going to review the indictment with you initially prior to entering the plea agreement process so that there's a clear understanding of what you were originally facing. There's a total of 21 separate charges in the indictment. Counts 1 through 9 each allege aggravated murder as an unclassified felony, and each also allege 3 aggravating circumstances. There's 1 firearm specification as to the first 9 counts. There's also a firearm forfeiture specification as well. And if you had been convicted on any 1 or more of counts 1 through 9 and any 1 or more of the aggravated circumstances in each of these counts, you would possibly face the death penalty. You understand that?
Yes, Your Honor.
The counts 10 through 17 each allege kidnapping, and each also allege the one firearm specification and 1 firearm forfeiture specification. You understand that? Counts 18 through 21 allege felonious assault, and each also allege 1 firearm specification and 1 firearm forfeiture specification as well. You understand that?
Yes, Your
All
Honor.
right. I'll now explain the charges that are part of the plea agreement. And this plea agreement is, as the prosecutor stated, you'll be entering a plea of guilty to count 1, aggravated murder as an unclassified felony. Count 2, aggravated murder as an unclassified felony. Count 3, aggravated murder as an unclassified felony. Count 18, felonious assault, a felony of the 2nd degree. And count 20, felonious assault as a felony of the 2nd degree. In exchange for your pleas of guilty to counts 1, 2, 3, 18, and 20, the state will dismiss all the, and actually have dismissed all the aggravating circumstances that would have made you eligible for the death penalty as to counts 1 through 9. All firearm specifications that were applicable as to counts, all 21 counts, are being dismissed. You're going to agree to forfeit the firearm only, and then the state obviously then will be dismissing counts 4 through 9, the other aggravated murder counts, counts 10 through 17, the kidnapping charges, and counts 19 and 21, felonious assault charges. So with the dismissal of all the aggravating circumstances in counts 1 through 9, and in particular counts 1, 2, and 3, the counts you are entering your pleas to this afternoon have eliminated the potential for any death penalty. You understand that?
Yes, Your Honor.
In addition to pleading guilty to counts 1, 2, and 3, you and the state are recommending what I refer to as a jointly recommended agreed sentence as to these 3 counts, and I'll discuss the other 2 momentarily. In each of these 3 counts, you agree that the court will impose today a sentence of life in prison without the chance of parole for count 1, the same sentence in count 2, and the same sentence in count 3. And all of these sentences will be served consecutively with one another. That may sound somewhat unusual because life without parole is life without parole. But essentially, they're being ordered to be served consecutively so that it is unmistakably clear that you will spend the rest of your life in prison with no chance for parole. So you understand those sentences and the consequences of those sentences.
Yes, sir.
And again, these will be served consecutively with one another. As to counts 18 and 20, They are second-degree felony offenses, and the jointly recommended agreed prison term as to each of these two counts is a minimum of 8 years on each count. Each minimum sentence will be served consecutively with one another, so I total those to arrive at a total minimum prison term of 16 years. Under the Reagan-Tokes Indefinite Sentencing Act, I'm required then to take 50% of only one of the most serious second-degree felony offenses, which would be 4 years. I then add that to the total minimum sentence to get to 20 years. So if this was a Reagan-Tokes sentencing only, the indefinite prison term you would serve is 16 to 20. Obviously, that 16 to 20 years it's going to be served consecutively as well, but it will be totally consumed, if you will, by the life without parole prison sentence, which is why we are eliminating any reference to potential early release date, because it's a vain act. There is no early release date for you. You understand that? So you understand the sentences that are going to be imposed at this point in time as to counts 1, 2, and 3, and as to 18 and 20. And just so that there's no misunderstandings, no misconception of anything that I'm talking about today, I will impose the sentence I've just discussed with you today. And we will proceed with that sentencing, obviously, at the appropriate point in time. And other than what I've just explained to you in terms of the number of charges that you're in your pleas to, the agreed prison sentence that you're entering your pleas to, the dismissal of all the aggravating circumstances in counts 1 through 9, the dismissal of all the firearm specifications in all counts, and the agreed sentence, obviously, that I've just gone over with you. Has anyone else made any type of a promise to you whatsoever to have you enter into this plea agreement and these agreed sentences this afternoon?
No.
I mean, I promise that I will impose the sentence that I just described to you, but other than that promise, no one else has promised anything else to you to have you enter your pleas of guilty this afternoon.
No.
And before we start the actual plea process and the sentencing process, it's important that I advise you of the nature of the various charges that you're pleading guilty to and the potential penalties that you are exposed to, irrespective of the agreed sentence. In count 1, it is alleged that on or about June 15, 2023, in Claremont County, Ohio, you purposely and with prior calculation and design caused the death of Clayton Dorman. This is in violation of 290301 and is an unclassified felony. Do you understand the nature of count 1?
Yes, Your Honor.
Count 2 alleges that on or about June 15, 2023, in Claremont County, Ohio, you did purposely and with prior calculation and design cause the death of Hunter Dorman in violation of 290301, and that is also an unclassified felony. You understand the nature of count 2.
Yes, Your Honor.
Count 3 is on or about June 15, 2023, again in Claremont County, Ohio. You did purposely and with prior calculation and design caused the death of, did I say Hunter was, Chase is count 3, Chase Norman, an unclassified felony. You understand the nature of count 3. Count 18 alleges that on or about June 15, 2023, in Claremont County, Ohio, you knowingly caused or attempted to cause physical harm to Alexis Skeen by means of a deadly weapon or dangerous ordinance, a firearm, in violation of 290311A2, a felony of the second degree. You understand the nature of count 18.
Yes.
Count 20 alleges that on or about June 15, 2023, in Claremont County, Ohio, you knowingly caused or attempted to cause physical harm to Laura Dorman by means of a deadly weapon or dangerous ordinance, again, a firearm, and that, again, is in violation of 290311A2. You understand the nature of count 20.
Yes, Your Honor.
The possible sentences for these various counts are as follows. As to counts 1, 2, and 3, those are all aggravated murder, all unclassified felonies. The possible sentences you could receive would be serving 20 years in prison before eligible for being for eligibility for parole, 25 years, a full 25 years in prison before eligibility for parole, 30 full years in prison before eligibility for parole, and then life in prison without the possibility of parole. You understand that?
Yes, sir.
Yes. The maximum sentence I could impose, and that's count 1, would be life in prison without parole. You understand that?
Yes, Your Honor.
Count 2, life in prison without parole. You understand that?
Yes, Your Honor.
Count 3, life in prison without parole. You understand that?
Yes, Your Honor.
And I can and will order all of those 3 sentences to be served consecutively with one another. You understand that?
Yes, Your Honor.
As to counts 18 and 20, because they are felonies of the second degree, is a little more complicated to get to that, but you need to know what the penalties are and how we get there. Both of these, again, are felonies of the second degree. They carry a minimum of 7 or 8 years in prison, and there are 2 charges. They both carry that same minimum prison option. And what I have to do is select a minimum sentence for each of those counts. And because they're 2 separate victims, I can order them to be served consecutively with one another. And once I determine that they will be served consecutively with one another, which will happen today, I then, once I have selected the minimum sentence, I add those together. I then take 50% of one of the most serious second degree felonies, add that to the minimum prison term total, and that's the indefinite prison sentence you could receive in this case. So as I'm going to impose an 8-year minimum sentence on each case, I'll total those together as will be served consecutively for a total of 16 minimum years in prison, a maximum prison term of 20 years. And again, those are going to be subsumed, if you will, by the indefinite or by the life in prison without the possibility of parole. But we understand how we get to that point.
Yes, sir.
And as to each of the first degree, or as to each of counts 1, 2, and 3, I can impose a maximum prison or maximum fine of $25,000, totaling $75,000. I will not do that. As to counts 18 and 20, the maximum fine on each is $15,000. Accumulated would be $30,000. I'm not imposing a fine in that case. You understand that?
Yes, sir.
And as a result of your pleading guilty this afternoon, Mr. Dorman, you're waiving following constitutional rights. You're waiving your right to a jury trial. You understand that?
Yes, sir.
You're waiving your right of confrontation, which means if you had gone to any trial, your attorneys wouldn't have been able to question every witness under oath that came into court to testify against you. You understand that?
Yes, sir.
You are waiving your right of the compulsory process, which means if you had gone to any trial and you needed witnesses to help you defend yourself, I could have issued a subpoena as a court order. They would have been required to appear, even if they told you they did not want to be involved in your case. You understand that?
Yes, sir.
You are waiving your right to require the state of Ohio to prove you guilty beyond a reasonable doubt as to all the essential elements of the charges I've just read to you, regardless of the trial you chose to pursue. You understand that?
Yes, sir.
You are waiving your right against self-incrimination by pleading guilty. Obviously, that's the most incriminating thing you could say. But had you gone to any trial, no one, not even this court, could have ordered you to take a seat in the witness chair and testify against yourself for any reason. You understand that?
Yes, Your Honor.
By pleading guilty, you are surrendering the presumption of innocence that you have this afternoon. You understand that?
Yes, Your Honor.
By pleading guilty, you'll be making a full and complete admission of your guilt to each of the 5 charges I've just explained to you. You understand that?
Yes, Your Honor.
You'll also be admitting the truth of the facts that the prosecutor is going to read shortly that would enable me to find you guilty and proceed with sentencing. You understand that?
Yes, Your Honor.
And you are also accepting the jointly recommended agreed prison term, and you're waiving your right to appeal the sentence that can be imposed in this case. Is that correct?
Yes, Your Honor.
Throughout this process, you've been represented by Mr. Myers and Mr. Haynes. Have they fully explained all 21 charges to you? The aggravated circumstances that were involved with counts 1 through 9, the other specifications that were involved in all 21 counts. Have they done that?
Yes, Your Honor.
Have they explained in particular the nature of counts 1, 2, 3, 18, and 20, as well as the possible penalties associated with those 5 charges?
Yes, Your Honor.
Have they also discussed with you and shown you all the to them that would, in essence, support any finding of guilt in this case?
Yes, Your Honor.
Have they fully discussed with you any and all possible defenses that you may have had in this case?
Yes, Your Honor.
I'm sure they have also fully explained to you that by pleading guilty, you're withdrawing the not guilty by reason of insanity plea. Is that correct?
Yes,
And you agree with that?
Yes, Your Honor.
They're also withdrawing the motion for the hearing on the serious mental illness that was scheduled for Monday, and you agree with that as well.
Yes, Your Honor.
I'm sure that they have fully explained all the constitutional rights that you've just waived. Is that correct?
Yep.
And they have also fully explained the jointly recommended agreed prison sentence that will be imposed this afternoon. Is that also correct?
Yes, Your Honor.
By accepting by accepting the jointly recommended agreed prison sentence, you're waiving any option that you have, right you may have had, for a pre-sentence report through the adult probation department. You understand that?
Yes, Your Honor.
And you agree with that?
Yes, Your Honor.
And you're also waiving any right you may have had for an additional mental health evaluation through the probation department as part of the pre-sentence report, correct?
Yes, Your Honor.
Have they answered all your questions? Oh, wait.
One moment.
Mhm.
I mean, sometimes that's the way we don't dig in sentence. We don't need it. It's with this. That doesn't. Let's still give you.
Yeah, that's what I'm saying. I didn't know if that told you.
No.
You're not.
John, I think we.
Okay, all right. Have they answered all your questions thoroughly? No. And at this point in time, are you satisfied that Mr. Myers and Mr. Haynes have effectively represented you up to this point in time as to each and every aspect of the case that has transpired up to this point in time? That includes all the evaluations you've had for not competency, but for the NGRI plea, the SMI portion of this. You're satisfied that they have fully, effectively represented you up to this point in time.
Yes, Your Honor.
And you're obviously then satisfied with them as your attorneys.
Yes, Your Honor.
Then, as to count 1, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 2, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 3, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 18, felonious assault in violation of 290311A2, how do you plead?
Guilty.
And count 20, felonious assault in violation of 290311A2, how do you plead?
Guilty.
Are you entering each of these pleas of your own free will?
Yes.
No one's forced you to enter these pleas at all, correct?
No.
All right. And on behalf of the state, the statement of facts?
Yes, man.
Yes. Mhm.
Please support. On or about June 15th, 2023, 1965 Laurel Lindale Road, in Claremont County, Ohio. Defendant did purposely and with prior calculation and design cause the death of his 3 children. Clayton Dorman, age 7, Hunter Dorman, age 4, and Chase Dorman, age 3. On that date, Judge, June 15, 2023, the defendant returned home early from work and had his family, including his wife, Laura Dorman, with him. all three of the boys joined him in the master bedroom for a nap. At some point after lying down with the four of them, the defendant got out of bed, opened a gun safe that was next to the bed, removed a Marlin Model EC-22 rifle from the gun safe and loaded the magazine. The defendant shot his son, Hunter Dorman, twice while in the bedroom. His wife, Laura, began to render aid to Hunter and yelled for the other children to run. Laura's 14-year-old daughter, Alexis, who had been watching television in the family room, made her way to the master bedroom and witnessed the killing of Hunter. Alexis immediately began to run and indicated that Chasen had fled out the back door. Clayton had fled out the back door, and that Chad Dorman was following Clayton. She ran to help to try to protect Clayton. Anyway, the three of them go out the back door. Clayton's first, then there's the defendant, and then Alexis. Alexis witnesses the defendant chase after Clayton, raised his rifle, fired numerous shots at Clayton as he fled, and saw Clayton fall in the field after he was struck by the gunfire. Alexis then watched as the defendant approached Clayton while he's injured, lying on the ground, defenseless, and saw the defendant put a bullet in Clayton's head, killing him. The defendant, Alexis then, Your Honor, ran back and fled into the residence where she picked up the youngest child, the little 3-year-old boy, Chase. She attempted to flee the residence with Chase to protect him, but the defendant saw her crossing the yard. The defendant gave chase, pointed the rifle directly at Alexis' head, and threatened to shoot Alexis if she did not drop Chase. Alexis put Chase down. He's crying the whole time. The defendant then pointed the firearm at Chase's head, but it just clicked. The magazine was empty. Alexis begged for the defendant not to shoot her. Chase then saw his mother, who had come outside at some point, trying to render aid to Hunter. So Chase runs to his mom. And then there's the very difficult situation that evolved where Laura and the defendant struggled over the weapon. Laura was bitten as she tried to protect Chase from the defendant. The defendant bit her. She put her thumb over the end of the barrel in an effort to stop the bullet. She was shot in the thumb. Ultimately, she had to drop Chase. During this point in time, the defendant was able to reload the firearm. He pointed the gun at Chase's head and executed one round to his skull. Alexis, Your Honor, suffered serious physical harm as a result, or psychological harm as a result of being held at gunpoint, forced to surrender Chase to the defendant for his execution, and witnessing her stepfather execute her brothers. Laura suffered serious physical harm, obviously, as she was shot through the thumb. Police arrived. There was really nothing that, despite her desperate fighting to save the lives of her boys, there's nothing Laura Dorman could have done. Surrendered without incident. Acknowledged immediately, he did it, take me to jail. He later gave statements, Your Honor, that he had been thinking about killing his boys since October, that these thoughts of having to kill his sons were weighing so heavily on him that he hadn't slept in a few days. And those are the facts, Your Honor. Those are the facts that led to the death of Clayton Dorman, Hunter Dorman, and Chase Dorman, and the permanent, irreversible injuries to the psyche of Alexis and also Laura. Thank you.
Thank you. Mr. Myers, any issues with those facts for the purposes of the plea?
Your Honor,
On behalf of Mr. Dorman, we accept and acknowledge that those are the operative facts that the state relied upon to carry its burden of proof at trial, and that those facts would have succeeded in carrying the burden of trial had the jury rejected the insanity defense. We're pleading guilty to that. I'm trying to support to you, like anybody else in the court. I just ask this court to bear in mind the three reports from three different psychologists that are before the court have been for a while. And simply add to dispute the sequence of the events, mortality of the events, or tragic events, but to add that but for some of the mental health issues that Chad had failed to address. He goes under blood, failed if ever they encounter that again. That but for those mental health issues, see, it's fair to say certainly 2 out of the 3, if not all 3, it's politics, will acknowledge the odds this happening. But I also, by adding those facts, further acknowledge we're withdrawing the insanity defense. We understand the dispute between the experts on that. But Chad stands ready to proceed with carry and accept responsibility.
Okay. And Mr. Dorman, up to this point in time, once again, have you been able to hear and understand everything I have discussed with you, what your attorneys have stated, what the prosecutors have stated?
yes, Your Honor.
Do you have any questions, any misunderstandings, any disagreements with anything that's been said this afternoon?
No, Your Honor.
You're able to hear the statement of facts that the prosecutor read regarding the sequence of events as acknowledged by Mr. Myers to be accurate. Do you also believe that those are true?
Do I believe they're true? No.
Okay. You understand that they're accurate? That, as your counsel has said, that's accurate?
Yes, Your Honor.
And I need to review the guilty plea form with you at this point in time. And again, the guilty plea form sets out the charges that you're in your pleas to. They have counts 18 and 20, felonious assault as a felony of the second degree, has the statutory provisions, has the possible penalties that are involved for those. 2, has the aggravated murder counts and counts 1 through 3 with the maximum sentence that penalties that are set forth for those 3 charges as well, potential fines, has the dismissal, if you will, of counts 4 through 9, 10 through 17, 19, and 21. And we're waiving any requirement to regarding Reagan Tokes and any post-release control because that's inapplicable and is a vain act. And it also sets forth the jointly agreed recommended sentence of life without the possibility of parole as to counts 1, 2, and 3. Each of those sentences to be served consecutively with one another. And also the minimum prison term of 8 years on both counts 18 and 20, accumulated to a total minimum prison term of 16 years with a maximum prison term of 20 years, again subsumed, if you will, by the life without parole as to the first 3 counts. Were you able to review this with Mr. Myers and Mr. Haynes before you signed it?
Yes, Your Honor.
Did you understand everything that was written on this document and the consequences of signing it?
Yes, Your Honor.
And did you sign it of your own free will?
Yes, Your Honor.
It has your signature on the back page. It appears to be in blue ink, but you signed this voluntarily. after reviewing it with counsel and understanding the full consequences of signing this guilty plea form.
Yes, Your Honor.
Based upon your answers, then, Mr. Dorman, I'll find that your pleas have been entered knowingly, intelligently, and voluntarily, that you're guilty of counts 1, 2, and 3, each aggravated murder and classified felonies in violation of 290301A, and you're also guilty of felonious assault as alleged in counts 18 and 20, second-degree felonies in violation of 290311A2. And before we proceed with sentencing at this point, I'm going to take a short pause. Everybody can stay in place because the two victims, Ms. Laura Norman and Alexis, want to be here. And at this point in time, all cameras down, all photo, any cell phones, any
When
still.
this happened, all three psychologists basically acknowledged that. Dr. Dreyer acknowledged it. They don't agree on whether it qualifies as long enough for serious mental illness or whether he had some appreciation of the legal wrongfulness of what he did. But the fact is, he loved those boys more than anything. And he was ill. He was sick, profoundly sick at the time. There's nothing more he can say at this point except that he's sorry about that. He did it. He acknowledges that. He's taking responsibility for it. He can't bring those boys back to do anything to do it. I think he would wish that he stayed at the little clinic for a little longer than he did. I think he wished that in hindsight he signs there before this happened. Tried to power through it. He wouldn't do that again. Till it was too late, he couldn't. He was out of control.
Anything further on
Sorry for
that?
that. No.
Mr. Dorman, is there anything you want to say on your own behalf before I impose sentence? No? Well, there's nothing that I can add to Alexis and Laura Norman. Those were two of the most compelling statements I've ever heard. With that said, Mr. Dorman, as to count 1, I'll impose a prison sentence of life in prison without the possibility of parole. No fine will be imposed. As to count 2, it'll be a life prison term without the chance of parole. And count 3, it'll be life in prison without the possibility of parole. These 3 counts and these 3 sentences will be served consecutively with one another. As to count 18, it'll be an 8-year minimum sentence. As to count 20, it'll be an 8-year minimum sentence. They will be served consecutively with one another for a total of 16 years as a minimum sentence. The maximum the sentences in counts 1, 2, and 3. All aggravated circumstances have already been dismissed. Firearm specifications will be dismissed. You will forfeit the firearm that was used in this case. It will be forfeited to the sheriff's office for destruction, and it must be destroyed. Appeal for this sentence, so you will serve the rest of your life in prison. Will order judgment for court costs. You have been held in the county jail since June 15th, so there's 415 days that you've served in jail up to this point in time. That will be credited towards the life without parole. There's no restitution and no fines will be imposed. Anything further on behalf of the state, Mr. Colby?
No, Your Honor.
Mr. Myers, Mr. Haynes, anything further?
No, thank you.
Covered everything satisfactorily?
I believe so.
Yes, sir.
Thank you. All right, thank you.
Thank you, guys.
He'll be committed to the sheriff. Bond obviously will be revoked, subject, well, there was no bond anyway, but be committed to the county jail for conveyance to the state payment system. Yeah.
All right, guys. So you saw that there. Life, no parole. I have to say, my opinion on this case is I think life without parole is probably too good for what he did to his kids. But I think also something I saw alluded in this hearing that I think is interesting that was kind of just glossed over is a father who does something like this to his children. I think there's an indication there that more likely than not, he's got mental health issues. So I was expecting, especially once the statement was no longer admissible, that there would be a full-throated mental health defense put up in this case, and that the heinous nature of the case lent itself, especially when you see some of the video where you see him wandering around Kroger. There's various pieces of evidence that have matriculated out over the months that have indicated that this man was having problems. He was hospitalized with mental health issues. And I think it really speaks to the idea here that, we have to address, especially when it comes to a case like this, we have to address the implications from the case in terms of mental health, mental disease, things of that nature. So while I don't believe this man should necessarily ever see the light of day, if he's not well, but at the same point, a crime like this indicates to me, screams out to me that this guy was having mental health issues. And it does not mean that he can't get himself to a point, hopefully, where he can, with support, with monitoring, get to a point to where he can function better. But to just lock him in a cell, not address the mental health concerns, and not have a mental health plan in effect, I think was a disservice to him by his attorneys. But I think that, that's the state of the court system that we have right now, especially when it comes to crimes like this. But what he did was horrifying. What he did definitely deserves a life sentence. But it also, to me, again, as a proponent of that it should be life with parole review, always. Doesn't mean they ever get out. Doesn't mean they ever be allowed to walk the streets. It's just that I think that you have a correctional system where it says we give up on you and there's no path. He's still living. He may not deserve to be living in the eyes of many when you look at the crime he committed. But at the end of the day, he's still a human being and we still need to deal with that. And our system needs to be humane. Our system needs to deal with that. And our system needs to be able to deal with correcting and putting plans in place to help correct the deficiencies that led individuals here. And in doing that, we will understand. See, it's in doing that, in making that investment in corrections, that actually starts to give us more information as to how we can better predict these things. In other words, if somebody really dug in and he was forced to participate as part of his correctional plan. Now, if he chooses not to, he chooses not to. He sits in jail for the rest of his life. If at some point in his life he says, you know what, I want to try to get on a track to where I go before the parole board, put a plan in place, and get either a better way, again, there needs to be levels. And I'm not advocating that this guy ever walk free with no supervision. But I think that our correctional system needs to provide levels, needs to provide an avenue to better themselves within the correctional system, possibly even getting to a point where he could go and contribute to society in more of a monitored, maybe, halfway house setting, correctional living facility. I think would be, to me, a great evolution to where he could work his way up to where, all right, this is an individual that can go work a job and contribute to society, start paying back the money that he's, again, remember, it's society's payment when we lock a man away for the rest of his life, right? We pay for him now, and it is at great cost. It is at a cost far greater than what he would probably cost society if he was out there living on his own, because I believe it's something to the tune of about $40,000 a prisoner. Think about that for a minute. $40,000. Do you think if he was living in society that he would cost society $40,000? No. I mean, he might make $40,000 a year. He's going to pay taxes on some of that, but his cost, the cost to house himself, the cost to feed himself, will not be that alone. That might be something he was raising his family with, and he combines incomes with, but the cost is immense. And we have to deal with that, because what's happened is our prison systems become for profit. And I know many may say, well, why would you want to take a case like this and talk about that? Because it's cases like these that we talk about reform in, because these are the tough ones. These are the ones where this individual's committed the most heinous act society could ever allow committed. He killed his children. And he did it in a way that's just absolutely unexplainable that a father could do that. And as a father of three boys, soon to be 4 boys in a week, I can't even imagine doing that. Can't even imagine at a point where my mental health would deteriorate to a point that I would even say, this is what I need to do, or this is how I need to do it. It's just unthinkable, but he did it. And now we own him, and society owns him. And there's a cost every single year to house him and put him in there. And to me, it's a great injustice to think that what we do is we just warehouse a human being and don't require them to be better. Don't require them to have to, at some point, even with a life sentence, have to get back to a point where they're contributing again to society, to where they can go work. They may never get the freedom to work without they may never again get the freedom to work without living in a correctional living environment, but they should have to go out and contribute, repay the debts, repay what they're costing society to house them, and come back and, in the name of their victims, contribute in some meaningful way to society again. And when we start to learn how to treat the prisoners and the convicts better, that will start to bottom up, matriculate its way. There's an idea that we have to go top down. It's bottom up. When you take care of the bottom, that works its way all the way to the top, believe it or not. And some of you may disagree with that, but I don't. I believe it starts here. We want a better society. We make it better here when we take the person who's committed an act like this, the ultimate act, the ultimate betrayal of trust, and we figure out how to correct the issues with that person. We will begin to start seeing the blueprint of how we correct many, many other things that emanate from that. Anyways, that's where I leave it with. Horrible case, sad case. Heart goes out to the family. I hope the surviving family members are able to find peace. I don't know how they ever will. I hope the young lady that I believe he's got a daughter that survived this. I hope she's able to find peace in her life and not go out and have the same struggles as her father did. And I can only imagine the wife, or I don't know if it was his wife or his girlfriend. I don't know if they were married. I think they were married, but what a horrible case. So hearts out to them. And hopefully he finds the help he needs within the prison walls. I doubt he will. I think it's going to be a very tough time. But that's the future he has decided for himself when he decided to do these acts. Anyways, with that said, guys, stay tuned. We got lots of things coming up, lots of trials coming up that we're going to be covering. We're going to be continuing to do some specials on the Ty Tucker situation, so stay tuned for that. They're coming, I promise. And until we talk again, guys, let justice prevail, and I'll talk to you soon.